My name is Carl Pearson. I'm a New York attorney and I represent homeowners throughout the United States in defending foreclosure actions and in quiet title actions. You probably know about foreclosures, but let me tell you about quiet title actions, which is the homeowner's own foreclosure action against the bank. In this video, I'm going to have the following subjects, and I'm reading the topic headings now. The quiet title action, how REMIC Tax Law governs securitization and limits property transfers. The pooling and service agreement states that New York law governs securitization issues, where the action should be brought. If your loan was securitized, there's a 90% chance of finding substantial defenses to a foreclosure action. What Bank of America and MERS are saying about securitization. The cost of the quiet title action. Quiet title actions can work even if you have already lost your property. You will need an experienced, willing attorney. The difficulties in finding a willing attorney locally and saving several $1,000s by using only one lawyer. And to speak with me about the matter. First, the quiet title action. The quiet title action for homeowners is much more than a quiet title action. The complaint should have claims of any significant wrongdoing rising to the level of a defense to a foreclosure lawsuit or non-judicial foreclosure, including predatory lending practices and unclean hands. A quiet title action alone would allege that for a number of reasons the defendants do not own or were not authorized to act by the owner of the original red ink note and mortgage, and ask the court to enter a judgment to such effect, including a provision ordering the defendants not to assign any of their alleged interests to any other person. In this way, a defendant who could have an interest is required in several weeks to prove its interest or lose it. A more complete quiet title action, because of the rule that you cannot split a cause of action into multiple lawsuits, should include allegations where appropriate of loan modification fraud, failure to provide the financially troubled homeowner with an option to remain in the property through a loan modification agreement based on the present reduced value of the property and present interest rates, if the homeowner could afford to pay such revised mortgage, and the various ramifications of securitization, including the splitting up of the note and mortgage, thereby nullifying the mortgage, and a defense of frustration of the homeowner's performance under the mortgage, plus various other defenses. Other securitization problems, such as fraudulent documents, robo-signing, failure to create valid assignments, and missing powers of attorney, are issues dealt with in the quiet title part of the action. REMIC Tax Law governs securitization and limits property transfers. Remember the word REMIC, R-E-M-I-C. It's an IRS term referring to real estate mortgage investment conduit, enacted in 1988 by a compliant Congress and President at the request of Wall Street to make securitization through public offerings possible a few years later. If the investment banking industry, lenders, and banks fail to comply with REMIC requirements, such as the requirement of having good title to all properties transferred to the trust and done so within a short period of time with a cutoff date, there is a legal question of whether non-complying transfers were valid at all because they were done in violation of REMIC rules. Thus, scrutiny of transactions from a REMIC standpoint could produce a basis for winning a quiet title action or encouraging the bank to give a very reasonable loan modification agreement as a more acceptable result for the bank than a total loss. The pooling and service agreement states that New York law governs securitization issues. The pooling and service agreement with the various securitization trustees calls for application of New York law to be used when determining the legality and meaning of various securitization documents, including the pooling and service agreement itself and the certificates issued to investors. This gives the New York courts a much greater interest in quiet title actions because they are governed by New York law. Where the action should be brought. Although foreclosure actions by banks are brought by in the county where the property is located as a truly local action, enabling the bank to file a lease pendens in the clerk's office to notify the world about the foreclosure action, there is no need for a homeowner to file his or her quiet title action against the bank, servicer, securitization, trustee, MERS, and others in the county where the property is located. It makes far more sense to sue in the place where securitization took place, where there are documents and witnesses needed to prove your case, and the court and substantive law are of the same state. Also, we should not forget the October 20, 2010 administrative order of the New York courts requiring a much greater attention to pleadings and claims by the bank's attorneys, with the result that it is more difficult for banks to litigate foreclosure and quiet title cases in New York than in other judicial foreclosure states. Accordingly, I recommend that quiet title actions be brought in New York County, New York. If your loan was securitized, there's a 90% chance of finding substantial defenses to a foreclosure action. There are about 20 things to look for in support of a quiet title action or wrongful foreclosure action or as a defense to a foreclosure action. I anticipate that 90% of the securitizations taking place during the period from 2005 to 2009 have defects sufficient to support one or more of these types of lawsuits. What Bank of America and MERS are saying about securitization. Bank of America's 10K SEC filing for fiscal year ended December 31, 2010 reveals that it is aware that it may not be able to enforce some of its notes and mortgages because of the securitization process, when it states in Exhibit 99.1 entitled Risk Factors, and I'm quoting now, many derivative instruments are individually negotiated and non-standardized, which can make exiting, transferring, or settling some positions difficult. Many derivatives require that we deliver to the counterparty the underlying security, loan, or other obligation in order to receive payment. In a number of cases, we do not hold and may not be able to obtain the underlying security, loan, or other obligation. This could cause us to forfeit the payments due to us under these contracts or result in settlement delays with the attendant credit and operational risk, as well as increased costs to us. Also, that's end of quote, also a recent announcement by MERS to its members, including the major banks, advised them, quote, we encourage members to bring foreclosures only in the name of the holder of the note, in the name of the trustee or the servicer of record acting on behalf of the trustee, unquote. What all this means is that MERS and the major banks realize that homeowners, if they sue, even in a counterclaim, could prevent the bank from foreclosing and from collecting on millions of notes and mortgages. I estimate that 90% of securitized mortgages are defective. It does require litigation to get this result because the banks are not going to voluntarily undo what they did. The remedy for homeowners, even homeowners who already lost their homes, will almost always require elements of a quiet title action and should actually include additional claims in their pleadings. Cost of the quiet title action. A quiet title action could, in theory, cost up to $100,000 to $500,000 or more, assuming various appeals and trials and a lot of deposition discovery, and that the homeowner is really trying to squeeze out the lender by showing that it failed to perfect its lien in one or more fatal ways. Don't expect the bank to turn over your interest to you quickly. You can expect a long and costly fight in some or even most cases. But this huge amount is wholly unnecessary for most homeowners. My approach is on a step-by-step basis to analyze the cost and benefit at each stage of the litigation so that the homeowner's decision to litigate or keep litigating is cost-effective. Thus, I set a cost based on my anticipated hours of work for the time to be spent by me in reviewing and discussing the facts and the proposed complaint with the clients, preparing several drafts of the summons and complaint, obtaining final approval, filing the summons and complaint, and serving the summons and complaint on the defendants.